Hi folks, welcome to SQE1 window. So today we are diving into the world of partnership. So think of a partnership as a business marriage, two or more people coming together to chase profits, not babies, hopefully without too much arguing over who will left the kettle on. So section 1 of the Partnership Act, we need to understand what it says. A partnership is the relationship between persons carrying on a business in common with a view of profit. Breaking it down, you need at least two people. It must be a business partners share management and they are in it for the money, not just a jolly good time. So, formation and name, good news. Forming a partnership is delightfully low maintenance. No forms, no filings, no fuss. As long as your arrangement meets section 1, congratulations, you are in business already. Of course, most sensible partners sign a partnership agreement to avoid drama later. And nonsense, they don't. So, naming your partnership is fun too, but Business Names Act 1985 says if you don't use all your surnames, you might need approval. And if you have more than 20 partners, relax. You can keep a list in the office instead of printing 20 names on every letterhead. I don't think people will do it this way. So, duration and property. The partnership are usually like the friends who say, I shall pop by 1 hour. They continue at will unless a partner gives notice or the partnership is otherwise dissolved. Partnership property is for partnership purpose only if it's bought with partnership money, bought in by a partner or acquired for the business. As part of the pot, think of it like communal snacks. In the office fridge, for example, everyone chip in, anyone uses, but don't sneak the biscuits home. Not at all. I hate people doing it. Duties of partner. So on the duties, the heart of partnership law say the partners owe each other fiduciary duty of utmost good faith. Essentially, don't stab your mate in the back ever. Statutory duties includes like rendering full account and information, no hiding the profit under the sofa under section 28. So section does not mean under the sofa, that's me who mentioned it. So, not secretly profiting from partnership transaction, section 29, not competing with the partnership without consent under section 30 of Partnership Act. Remember, the default rule is equal sharing. If you didn't write any agreement, it is equal sharing. Sharing, keep in mind, sharing of profit, loss, and responsibility. And partners are not in for a salary agreed otherwise in the agreement. So, or whatever is agreed between the parties. So no free coffee breaks disguised as wages at that point. Don't consider. So authority and liability. Every partner is an agent of the firm. Yes, that means each partner can bind the business to contracts. Authority comes in three flavors. Actual authority, expressly given. Implied authority, what's necessary to get the job done. Apparent authority, how things look to outside. Yes, appearance do matter in law. Liability is joint and several for all of them. For debts under section 9, that means if a partnership owes money, creditors can knock on your door, even if you are just making tea at that time. And don't forget holding out. If you let people think you are still a partner, you are a liable one. So, new and retiring partners and also expelled partner. Bringing in new partner does not settle them with all debts. Lucky them. Section 17, retiring partners, however, might still be on the hook for debts incurred while they were in the firm. Tricky? Right, it is. Expelling a partner is only possible if partnership agreement explicitly allows under section 25. So no sneaky what at lunch to get rid of the difficult one. The law protects mavericks. So The next thing we need to understand is how to dissolve it. Partnership can end in many ways. Expiration of term, completion of project, or notice given by the partners under Section 32 of Partnership Act. Death or bankruptcy of a partner. Illegality if the business turns out to be a front for visit duels. Visit duels at that point, it's over. Go. Court order if the partner is hopelessly obstructive, misbehaving, or the firm is losing money at that point. Court can order dissolution of partnership. Even after dissolution, partner's authority continues just enough to wind up affairs. Think of it as the tidy up stage after a messy party. So, consequences and insolvency. Under Section 39, after dissolution, partnership property is used to pay debts. Anything left over is shared among partners. If the partnership goes belly up, creditors claim first from partnership asset, then from personal asset if necessary. Individual creditors must wait until partnership creditors are satisfied. Yes, even Auntie Mabel, who lent you £50 in 2019. So, you need to pay her. So, for exam tips and pitfall, memorize the element of partnership that was under Section 1 of Partnership Act. Know duties of partners, distinguish authority types. What are different authorities, actual, implied, and apparent? Try to just keep in mind, remember that joint liability and holding out. That's a classic trap. Keep an eye on dissolution kind of things. Notice death, bankruptcy, or court can dissolve it. Don't forget about expulsion clause and retiring partner. Easy marks if you remember the law and the reasoning. So, partnership are a bit like tea and biscuits. Sharing is essential, but make sure everyone plays fair, or someone's going to end up with crumbs. Ta-da!